morning, everyone, and welcome to this session on binding corporate rules for international data transfers. I'm Nathan Ross Adams, the founder and MD of IT Loco, and I'm going to share a bit about what experience I have, what work I've done in the BCR space, and how I'll be sharing that with you, best practices, insights, so that you develop a well-informed knowledge about this international data transfer mechanism. So let me just start off by sharing my screen, which should pop up very soon. Okay. Great. So the session is about crafting effective binding corporate rules for international data transfers. And why I'm using effective, because there are BCRs out there that aren't effective. I'll be looking at the EU perspective, but most of the content will be tailored to South Africa specifically, because there's not much conversation about what actually happens within a South African context. But I've supported companies, I'm currently supporting companies with BCRs, groups of companies, as you'll uncover, and they are a very useful tool to encourage the free flow of data across borders. What you'll get from today's session is really an understanding of binding corporate rules. You'll also learn how to develop your own and then implement them, as well as guidance and examples based on what I've built over time. Now, feel free to pop any questions as we go ahead in the chat. Engage with the rest of the audience. Feel free to introduce yourself as well. The session is recorded, so you can refer to it later. And I've also captured the essence of today's conversation that we're having in the on the IT Loco website under the Insights section. So you can have a look at the summary of today's session over there. But let's get straight to it. So the context for BCRs is international data transfers. I'd like to, just from a technical perspective, distinguish between cross-border transfers and international data transfers. So the way I use the terminology, which is aligned with global best practice, is that a cross-border transfer is a transfer across different countries, but within one continent. So it's moving across the border within a continent. Whereas international data transfers generally refer to transfers from one country in one continent to another in another continent. POPIA does not make that distinction, though. It specifically says transferring of personal data outside of the Republic, which essentially means that it would apply for both cross-border data transfers as well as international data transfers. Now, the GDPR has its own rules for binding corporate rules, but what's important to understand here is that generally the rule is that a responsible party they are not allowed to transfer personal data outside of the country from which the personal data is originating to a third party who is in a foreign country or a third country. So that would be a country within the region or a country across the globe, unless certain requirements are met. And so one of those requirements is that they're subject to a law, that there is a consent of the data subject in specific circumstances. But the gist of it is that there are individual transfer mechanisms which allow you, as a responsible party and operator, as we'll see later, to transfer data across borders. They're known as transfer mechanisms. And so one of the transfer mechanisms that we'll look at today is binding corporate rules. And so, what are they? They, in a nutshell, are legal documents between companies in a group of companies. So, picture a very large multinational company that operates in South Africa, Zimbabwe, Mauritius, Singapore, South Korea, the USA, the UK. So, it's pretty multinational in nature. And in each territory, there is a registered entity company that ultimately is subject to one holding company, or the companies are in agreement with each other. And binding corporate rules essentially is a transfer mechanism that facilitates transfer of personal data between those groups of companies. I want you to think of it as a quasi compliance framework between the different companies in um, that group of companies. Just checking the chat to see if there are any questions so far. Okay, no, we're good. Okay, great. So moving on to the next slide, we'll look at what the elements of a BCR are. And really, they need to apply to and be enforced by every member in the group of company that undertakes or would receive transfers. Alternatively, a group of enterprises engaged in joint economic activity, including their employees. So this would be examples like a joint venture, a partnership, a teaming arrangement, a collaboration agreement between them. So whenever there is commercial activity, binding corporate rules could also play a role. And really, the binding corporate rules confer rights on data subjects. So they set out and give effect to and confer rights on data subjects. Um, from a contractual perspective, this is actually a pretty interesting question or interesting point, because although lawfully or by law it confers rights on the data subjects or on data subjects, the question arises whether you're essentially creating a contract for the benefit of third parties who are data subjects. But that's more on the legal technical side, and we won't get at that in today. But if you want to chat about that more, feel free to reach out to me. Then lastly, under the GDPR specifically, binding corporate rules are subject to regulator or data protection authority approval. However, our regulator, the information regulator in South Africa, has not specifically mandated that binding corporate rules be subject to regulator approval. It simply listed it as a specific transfer mechanism. However, the regulator would probably release a guidance note on these binding corporate rules in a way that would give more guidance on that. So that would be a guidance note specifically on international data transfers. Now, before we actually, I'm just going to see if I can bring up this second screen. Okay, so that should pop up now. Okay, great. So in other words, it's unclear whether the South Africa's information regulator needs to approve it, but stakeholder engagement could give answers to those questions. I'm going to park that one for now and address it in a later insights post from IT Lawco. But for now, so what are the typical contents of BCRs? They would capture the group structure of the companies and the companies within the group that will be subject to the BCRs, as well as their contact details and individual information or data protection officers. Please pay particular note to this, because if you have an international group of companies or a multinational group of companies, what typically happens is they'll be subject to multiple data protection laws. And under the GDPR, their data protection officers are preferably external providers and provide data protection services to companies subject to the GDPR. But in South Africa, the approach is that the information officer is the managing director or CEO of an organization by default, and they can designate other people to perform that function. But typically, the responsibilities and accountability cannot be delegated and needs to be kept internal. The same would apply from a company law perspective, in that the directors must manage the affairs of the company. They can delegate their rights and their authority, but they can't delegate their responsibilities. And the same would apply in the case of a joint venture or teaming arrangement where there'd be a group of companies engaged in economic activities. Now, the BCRs also contain details of data transfer, so where it's going. It would essentially be a map of where data would be transferred. A record of processing activities would be pretty useful for this, as well as a map of those activities. And then also the types of personal data involved, categories of data subjects, categories of personal data, duration for processing purposes, all of those information, types of information that are typically contained in a record of processing activities. The BCRs would effectively be legally binding in nature. In other words, it's an agreement both internally and, when I mean externally, it will apply to how those entities within the group of companies engage with other service providers or other processors of personal data within the processing chain. The BCRs also capture the application of the data protection principles, or in POPIA's context, the data protection conditions. Rights, as we've mentioned. Now, it also needs to deal with the apportionment of liability when a member of the group specifically doesn't comply with the rules set out in that agreement and how it will be managed, as well as data subject access requests. Okay. Typically, there are two types of BCRs. That would be controller responsible party transfers. So where one responsible party within a group of company is transferring personal data among other responsible parties. Alternatively, there could be operator transfers or processor transfers, where a processor that's performing a function, or an operator is performing a function on behalf of a responsible party, needs to share the personal data within the group of companies. And so those BCRs would be customized to the operators. Now, how do we make this practical for you? What I've done is I've created a diagram of when I advise organizations how I would typically structure BCRs. So feel free to pop it. Well, you should be able to see it on the screen now. It says IT Lawco's approach to BCRs. And essentially, we have this entire contractual relationship starting from the bottom, where it's really an intra-group agreement. It's typically known as an IGA. And it's an overarching agreement that combines all those entities within the group to the actual agreement, which is known as the BCRs. And this specific agreement consists of various components. Now, as you will see on my screen, there is a flow upwards. In other words, it starts with general at the bottom and then it goes to more specific as it goes along. Now, the intra-group agreement contains the general legal principles, the parties, and it typically includes a schedule of the group, the members within the group, as well as their data protection officers, their information security officers, their company details, registration details, etc., to know which entities within the group are subject to the agreement. Then it will also include a privacy, moving up, a privacy compliance framework. So this would be the privacy compliance framework that the group agrees to at a whole. And it will include those personal data descriptions, the information that's typically in a ROPA. Moving a further layer up, the BCRs would contain guidelines for when a regulator, like the information regulator, or another government entity, or a court or a tribunal makes a request, and the procedures for dealing with those requests relating to personal data, how the parties will cooperate in doing so, etc. And then lastly, but probably the most meaty section of the BCRs, or the BCR governance framework. And this really would consist of a group privacy notice that would apply across the group and describe the transfer mechanisms that are in place. It would also include a data subject access request policy for the group, cooperation principles for any data subject access requests, data subject compliance and complaint rather it should be saying complaint procedure, but really it's about when a data subject makes a complaint, who's dealing with it, how do they decide which entity it goes to, etc. How often the BCRs will be updated, so versioning, and then importantly, which most people typically skip out in a BCR governance framework, is that it must contain a training and implementation schedule or plan for how the organization plans to give effect to not only the technical measures such as antivirus system, encryption, etc., but also the organizational measures such as employee training and how they'll be trained on the specific document as well, and the BCRs as a whole, and the principles that flow from it. Then it would also include agreements on an audit schedule that would set out when audits would take place, who can conduct audits, what the status of that audit is, and the procedures also relevant to audits. Now, there are several benefits and or advantages and disadvantages of using BCRs. The benefits really include that across the globe, it's recognized as the gold standard for transfer mechanisms. It's also great for PR if your company can say, your multinational company can say, look, we have binding corporate rules in place to protect the personal data of our data subjects and when we share data. It also sets clear guidelines for the different entities within your group, which creates predictability. And it's also a tried and tested mechanism in that it's replicatable. There are several organizations, multinational organizations across the globe that have adopted BCRs successfully. However, I can't just give you the glowy, flashy bells and whistles. I also need to let you know about the challenges of BCRs. They can typically be costly because of their various components and the fact that when you need to rely on external legal counsel to actually develop the BCRs, there's a lot of back and forth. And that back and forth typically is not due to any fault of legal counsel externally, but really the fact that there are so many moving parts that require re-review, reconsideration, and that can tend to be costly, not only from a money perspective, but from a time perspective. And in BCRs, depending on the sophistication of the group of companies or the entities involved, they can typically take quite some time to finalize and get approval by the relevant board. Now, within a South African context, there are some other considerations in addition to the global considerations for BCRs, such as our national data and cloud policy, which specifically deals with data sovereignty, data localization. When it comes to personal data, that is also government data, and so you need to consider those as well. Then South Africa's cybersecurity bill, which is pending at the moment, that specifically speaks about the cybersecurity standards that will be set at a national level, as they will impact the technical and organizational measures that your BCRs refer to. Then also the African Continental Free Trade Agreement, which generally focuses on the commercial the flow of commerce across borders within the region. So this would be a cross-border data transfer. And so, well, cross-border commercials, but there are data implications to the free trade agreement or what it's trying to achieve, and so that could be considered as well. And then lastly, the South Africa Cyber Crimes Act, which deals with unlawful and intentional actions or conduct relating to data. So in a nutshell, what we've done is we've looked at the context for BCRs. We've looked at what they are, what they mean, how to structure them, what they should contain, what the current rules are for them. And yeah, that's it for today's session. It's short and to the point. If you do have any other questions, feel free to pop me a mail or a message. There's also, I'll be uploading more content to the IT Lorca website, so you can have a look at that in more detail. Otherwise, have a lovely rest of your day and stay tuned for the next series of workshops or webinars for next month.